So with a replacement, in order to do that, the new vehicle would have to have the exact same value as the vehicle that's being taken back from you. And that's really hard to achieve because generally the subject vehicle, the one that's subject to litigation and is getting repurchased, is a year or two older than what's currently on the lot now. And as we all know, MSRPs tend to go up every year. So it's actually really hard to find a vehicle that has the exact same value. So a replacement can be really tough to achieve when you're talking about a lease.
Welcome back to Lemon Law Unpeeled, the Lemon Law podcast. I'm Emma.
And I'm Courtney.
And I'm Steven.
And today we're going to be talking about lemon law and leases, how leased vehicles are treated under lemon law, and what you should know in the event that you have a leased vehicle that's having issues. So generally speaking, most states treat leases the same as a purchase, right? There usually is not much of a distinction, with a couple of exceptions. There are some states that have different requirements or look at leases differently. They don't explain why, and honestly, I don't really understand why they do that. But Steven, I'll let you start with talking about Wisconsin, which is one state specifically that leases have different rights under lemon law than a purchased vehicle.
Absolutely. So in Wisconsin, leases do not qualify for lemon law under the state statute. Specifically, the statute applies to brand new vehicles that are purchased in the state. So the courts have ruled that a vehicle that is leased was not actually purchased. Due to this unique reading of the law, unfortunately, vehicles that are leased do not apply for lemon law. However, that doesn't mean you have no case if you do lease a vehicle in Wisconsin. Contrary to the state's lemon law, you are still able to pursue a breach of warranty claim in Wisconsin.
Yeah, it's very strange, right? Because some states exclude leases from lemon law, and then other states, which Courtney, I'll let you talk about, New York, that only allows leases to come under lemon law. You can talk about New York and New Jersey because they're right next to each other and they both treat leases completely differently.
So New Jersey loves leases, right? In New Jersey, leases will work the same way as a purchase. Whether you've leased a vehicle or purchased a vehicle, you can strive for damages under lemon law, meaning a buyback, or money damages under a breach of warranty theory. And in New Jersey, there's actually case law that says even after your lease has ended and you have surrendered the vehicle, you no longer have possession of that vehicle, you can technically still get a buyback. So still get all of your lease payments back once you've already surrendered the vehicle, which is generally something that would be really hard to do in any other state. But in New Jersey, there's actually case law that says that you can do it. New York, on the other hand, leases always raise a red flag because leases only fall under lemon law in New York. There is no breach of warranty protection for a lease. So if you have 4 visits to the dealership within the first 18,000 miles and you've met all those requirements of the lemon law in New York, we can bring a claim. But generally, we can bring a claim for breach of warranty in any other state if you don't meet that really high threshold of the lemon law. But in New York, unfortunately, we can't. We don't have that fallback option of breach of warranty. Now, have we done it in pre-litigation cases when we filed a claim directly with the manufacturer and they've still made a cash offer? Yes, absolutely. We've actually had a lot of success with that. But it's not something that we would want to go into litigation with, file a lawsuit on, because technically we do not have a breach of warranty claim in New York for leased vehicles.
Right. We want to be able to show that there's a substantial impairment too if we're going to go to litigation because all our eggs are in that one basket. And yeah, we could keep the claim alive because we can show that they were in within the requisite time period, but it's going to be really tough. And is it going to be worth it in the end? Who knows? Because the time period for litigation could also run out the time period for the lease, right? Leases are generally only 2 to 3 years. And if a client calls in, probably I would say near the end of 1.5 to 2 years, we try to settle it in pre-lit. We can't. We file the lawsuit and go to litigation, the timing is going to be really tight because New York also says that once your lease is up and you don't have the vehicle anymore, you no longer have any claims. So if a manufacturer really wants to be hard-nosed about it and extend the time period and make it longer and longer in litigation and kind of postpone or delay, they can. And then they could run out the clock on the lease and we're kind of left empty-handed. So you're right. New York is super, super tough for these cases. And then we have Colorado. Right? Colorado is a gray area when it comes to leased vehicles. If you go on the Better Business Bureau's website, they have a thorough summary for every state and their lemon laws. in Colorado, it specifically says lemon law does not apply to leased vehicles. And I think where that stems from is a reading of the statute. So the statute technically just says purchased vehicles, but it also says that it can apply to basically any person who has the right to bring a claim under the terms of the warranty. So to me, that would be whomever owns or leases the vehicle, right? Whomever's name is on that registration or lease agreement or buyer's order, because the warranty applies to their vehicle and they're the ones who have the rights based on it. But again, case law and lemon law is not very thick, right? Because these cases don't often go all the way to trial or even further than that. So it is a little bit of a gray area in Colorado as to how the owner of a leased vehicle would be treated and whether they would actually have a lemon law claim or not within that state. Lease vehicles, in terms of the type of defects that they have that we usually see buybacks for, Courtney, I'll let you talk about that. That is pretty much the same, right? That threshold is still there.
Yeah, it absolutely is. So whether the vehicle is leased or the vehicle is purchased, we'd be looking for serious issues, egregious issues that are literally preventing the vehicle from getting from point A to point B. No starts, the vehicle not cranking, not starting. For hybrid vehicles, batteries failing to charge. Transmission failures where a vehicle won't go into gear, can't go over certain miles per hour. For diesel vehicles, DEF issues where the vehicle might repeatedly go into limp mode. That's something that we see often. Engine failures, vehicles shutting down, stalling, leaving you stranded on the side of the road. Those are all of the big ticket lemon law items that we'd be looking at or looking for if we're trying to get a vehicle bought back. Like I said, anything that is literally preventing that vehicle from being driven.
Right. And that's not to say that we haven't gotten buybacks on less severe issues, but those are just clear-cut lemon law type defects, right? Then you have your defects that fall into a little bit of a gray area, and it kind of all depends on the type of repairs that are being made. How does the issue itself actually affect the drivability? But yeah, those are all really good, just clear cut. This is what we're looking for to be able to have a strong lemon law claim to be able to get the vehicle repurchased. Now, a common misconception that a lot of clients have is that their leasing company and the manufacturer are the same. Stephen, I'll let you talk a bit about the difference between a leasing company, even though it may have, Mercedes-Benz or Hyundai in the name of the leasing company. I'll have you explain how they're different and who actually holds the liability when it comes to a lemon law claim.
Leasing companies have no liability when it comes to lemon law, and neither do dealerships under new car lemon law. Instead, it's still the manufacturer that you're dealing with. So when a vehicle is repurchased, the manufacturer will pay off the leasing company. However, it's not the leasing company that we're dealing with. We are still going to be discussing with the manufacturer to try to get your case resolved. A lot of people think that we can get their payments lowered as well. However, since the leasing company is a third party and is not the manufacturer, it does not have the ability to change the terms of their lease and the monthly payments. So unfortunately, we're not able to change your monthly payment, but we are able to still discuss a repurchase with the manufacturer.
Right. They're completely independent because a lot of clients are like, I don't understand. It's my lease is with Kia Finance and you're dealing with Kia Motors USA. The two are actually completely separate entities. They're not one and the same. Kia Motor Company cannot dig into Kia Motor Finance's files, right? They're completely separate. As I describe it, one is a bank and one is a vehicle manufacturer. So they can't overlap. One does not have power over the other either. Like you said, when a lease is repurchased, the manufacturer does actually have to pay off the lease just like a consumer would in order to take title. Because a lot of clients, like you said, they ask, can they just terminate my lease? I don't want money damages. I don't care. I just want to turn in the vehicle to the dealer and walk away from it. And unfortunately, the manufacturer does not have the power to do that. Right? They are completely separate. And in order to pay off your lease or get rid of it, they would still need to pay it off and go through the normal channels that any consumer would have to. And Courtney, I'll let you talk about too a recent issue that we ran into with a lease in terms of doing a replacement, because replacements can be really tough under leases, right? Because of the collateral swap and all of that. I'll let you discuss how that comes into play.
Yeah, so with a replacement, in order to do that, the new vehicle would have to have the exact same value as the vehicle that's being taken back from you. And that's really hard to achieve because generally the subject vehicle, the one that's subject to litigation and is getting repurchased, is a year or two older than what's currently on the lot now. And As we all know, MSRPs tend to go up every year. So it's actually really hard to find a vehicle that has the exact same value. So a replacement can be really tough to achieve when you're talking about a lease.
Yeah, we're able to do it for financed vehicles because they'll just pay the MSRP difference. But what's different about a lease is that with a purchase, in the end, it's your vehicle, right? So you pay that MSRP difference and then you just finish out the terms of your loan and the collateral is yours. The problem with a lease is that you're going to be turning that vehicle back in. So if you fail to pay on that vehicle and it gets repossessed, the collateral that you have is not going to match what the leasing company is receiving. Whereas with the purchase, you're able to pay that up front. So the bank has it, they can hold on to it, and they have all of that in the event they take the vehicle back from you. Additionally, the manufacturer is unable to change the terms of the lease as well, right? They don't have that power. Some clients say, just lower my monthly payment. If they just, I'm paying $450 now, they lower it to $375, I'm good. But again, same sort of thing. The manufacturer does not have the power to turn to the leasing company and say, hey, we want you to lower this payment. We want you to change the terms of your contract. They just simply don't have that power. I even recently had it where a client, we were in the middle of a buyback. I told him, you need to continue making your lease payments throughout this process. He decided not to, even though being told to, and then came to me after saying, listen, this is hurting my credit now. I'm about to buy a house. Can you talk to, the financial group and have the manufacturer reach out to them and say, hey, in this whole agreement, let's add in that you'll take that off my credit. And I had to explain, no, that's just not possible because the manufacturer has no control over the financial institution. They can't tell them to do that. So you need to shore up your account and deal with that with the financial institution yourself. That's just not something we can do. Speaking of our purchase calculations, when it comes to calculating the refund that a leasee would receive, it's generally pretty much the same as when you have a purchase, but it can get a little complicated. Stephen, I'll let you talk about the issues that we've been running into recently in New Jersey in terms of what is the appropriate number to use on the lease to calculate that deduction.
So in New Jersey, there is a formula that is established by the statute to calculate what you're entitled back to for a repurchase. Part of that equation is determining what is the mileage usage deduction. So in New Jersey, the statute says it should be the lease price of the vehicle. However, the manufacturer will argue that it's the purchase price of the vehicle. These are two different amounts, and they can have an impact of thousands of dollars in deduction from your repurchase. In our view, it's the lease price. That is what needs to be taken into effect when calculating the mileage deduction. The manufacturer, though, persists on using the purchase price. Sometimes this results in us having to try to reach a medium ground with the manufacturer to resolve the case and try to get the most money back in your pocket.
Right, because it just doesn't clearly define what portion is supposed to be used. In the case specifically that we were arguing with them over, it was a huge difference. It was a difference between $12,000 and $3,000, which when it comes down to it, that makes a really big difference for the consumer, the amount of money they're going to get back, the money they have to put into another vehicle and things like that. So, and it is unfortunately a little bit of a gray area that's not clearly defined within the statute. So yeah, like you said, a lot of times we just meet in the middle so that everybody's happy and it's much less of an impact on the client's ultimate refund so that they can take the money and go get themselves a different vehicle. Other states though, like New York, PA, they keep it nice and easy. New York is just any miles over 12,000. PA is 10 cents per mile up to when the problem started. So whether it's a lease or a purchase, there's just no effect there at all. And then we have New York, wonderful New York, who just loves to do things its own way. So in New York, technically, under a lease vehicle refund, the manufacturer is allowed to take a deduction as well for what's called the rent charge. So if you pull out your lease and take a look, you have the boxes up top that say, your down payment, your monthly payment, total payments you will have made at the end of the lease. And then below that is a series of paragraphs that describe what went into this lease and how the numbers were calculated. Usually somewhere down where you see the residual value or the gross capitalized cost, you also see something called a rent charge. It has nothing to do with rental vehicles. It's just simply a charge that's put into each monthly payment because you're leasing instead of buying. So what you do is you take that total rent charge, divide it by the number of payments that you will have made, 35, 36 usually. And that number that comes up is deducted from each monthly payment that the manufacturer has to refund to you. And that number really changes wildly, and I'm not sure how they come up with it. I've had it where rent charges are $25 a payment. I've had it where they're $200 a payment. There's no real rhyme or reason there, at least that I know of, as to how they come up with that. But it can really also negatively impact a client's refund because that's additional monies that are removed. Now, not all manufacturers actually take the rent charge out of their refund. Most of them just add up your down payment, payments made, take the usage fee, and off you go. But some manufacturers really are sticklers for the rules, and they are going to take that money out. What was nice is I had a New York case where we were with one of those manufacturers that's known for taking that deduction. And fortunately, they had leased the vehicle initially in New Jersey. So when we calculated the rent charge total versus the New Jersey mileage deduction, it was significantly less. We were looking at $200 per payment that was going to be deducted under New York State Lemon Law versus a like $300 mileage deduction for New Jersey. So we ended up pushing it under Jersey, taking the mileage deduction, even though they would not have had a mileage deduction in New York because they had less than 12,000 miles on the car. When we balanced the scales out, it just didn't make sense. And so we went under a New Jersey calculation to avoid all of that. But most other states keep it pretty clean in terms of you don't have to worry too much. You'll get your down payment back, your payments made, minus any, mileage fees, negative equity, rebates, things like that we've talked about before when getting your refund. Now, documentation for these Lemon Law cases, it's pretty much the same for a lease. But Courtney, there is that same manufacturer always asking for, I believe it's the lease order that they're always asking for? What document is that, and what should the client hold on to?
Generally, you just need the same documents for a lease, but there is one manufacturer that always asks for the lease order, or when a case has been purchased, the buyer's order. It's something that the dealership will have. It just usually means an extra phone call to the dealership. Call the sales department of the dealership where you purchased the vehicle, and you can ask for the lease order, which is the equivalent of the buyer's order, but for a leased vehicle. Clients generally look at me like I have three heads when I first ask them for it, but if they just call up the dealership can generally give it to them.
Yeah, it's usually on the dealership letterhead. It's one page, and it just breaks down the terms of the lease, or sometimes it can make it look like you're purchasing the car, right? It has the cost of the vehicle, and then on the left-hand side, it actually has the lease terms, but it's just a single page with dealership letterhead on it that describes the purchase or lease, and that's what you want to hold on to. But again, usually the manufacturer can just get it from the dealership in the event that that's an issue. But other than that, leases are basically the same, and those cases are basically the same as they are in a purchased scenario, right? You want to have your current registration, your repair orders, your lease agreement in order to be able to push the case forward. And you want to make sure that you hold on to all of that information so that you are ready in case you have to bring a Lemon Law claim against your vehicle manufacturer. The only other issue that may arise is just leases are a shorter term, right? And when you turn it in at the end of the lease, it would be kind of the same as trading in a purchase, and that can really hurt your case too, right? And that's regardless of what state you're in. Courtney, I'll let you just talk about how not having the vehicle anymore just generally can be really tough. And since leases are kind of a short period of time that we're working with, sometimes can make it extra complicated.
Yeah, generally, if you no longer have the vehicle, you're not going to be able to get a buyback, right? The idea of a buyback is I'll give you back your money, you give me back the car. If you no longer have a car to give back, well, then there's no consideration there, and you're not going to be able to get a buyback. I think I mentioned earlier, though, New Jersey is one exception to that. There is case law that says that you can still get a buyback even after you've turned the vehicle in at the end of the lease, though having that worked in practicality is a little bit different than actually having that case there. So whether or not that's something that's realistically going to be accomplished would be anyone's guess. But yeah, generally, if your vehicle has been turned in at the end of the lease, we would just be looking at cash damages rather than a buyback.
Right. And cash damages under a lease are the same when you have a purchase, right? You still have your warranties. Your lease terms do not change. When your lease is over and you go to surrender the vehicle, this will not impair you from doing that. You should not have any issues from the settlement in turning in the vehicle off of the lease. Additionally, If you want to turn in your vehicle off a lease and get another vehicle by that same manufacturer, they're not going to care. They're more than happy to get you into a new car. It's not anything that's going to prevent you from being able to deal with them or work with them again in the future just because you had a leased vehicle and had a claim on it. But these are all really important tips because they all can come into consideration when you have an offer from the manufacturer and in terms of what to do, right? Let's say the client really wants the buyback, but we only have, 6 or 8 months left on their lease. And we have a cash offer and we know it's going to take more time to push the manufacturer along. Sometimes it's best just to take the cash right out the end of your lease and no harm, no foul, because that's kind of the upside to a lease rather than a purchase, right? You're not stuck with the car in the end. You still get to just turn it in at the end and move on with your life. Some clients look at it from the perspective of, okay, well, if you get me this cash from the manufacturer, technically I only paid X amount then for my vehicle, every month for 3 years. That's actually not a bad deal. So I'll just take it and be done. So it's all things and factors to take into consideration, especially if, you're a New York resident and you're listening to this and considering a lease. I always kind of give a nudge and say, hey, if you want to go to Jersey to do that lease, that might be best for you. So it's important to check out your lemon laws in your state to see, hey, how can I best protect myself in the event of getting a leased vehicle and having lemon law issues. Again, we have a comprehensive information on that on our website, lemonlawcar.com. You can also check out your state's attorney general's website. They often have a lot of information, and it's important to look at the wording, right? Do they say purchased vehicle? Do they say new vehicle? Do they say leased within the statute? That's where you can really find that information to see, okay, is this going to apply to me? And additionally, the Better Business Bureau also has a nice summary too that can include what type of vehicles are included in that state's lemon law. And then, of course, you always have our intake line that you can call for a free consult at 1-833-4CAR-LAW. And on that, we want to thank you for listening today, and we'll see you next time.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.